There are major advantages to applying for disability if you are over the age of 55 that you do not want to miss out on. Once you hit 55, the rules change. Under Social Security's medical vocational guidelines, also called the GRID rules, you can be found disabled if you can't do your past work and you are limited to light work. So what is light work? It means being on your feet for much of the day, lifting up to 20 pounds occasionally and 10 pounds frequently, and doing jobs that may involve a lot of walking or standing. If your doctor says that you're limited to light work and your past jobs were more demanding than that, you could qualify. I also like to tell people to think about it in the inverse. Being limited to light work means you can't do medium work. Social Security defines medium work as lifting up to 50 pounds occasionally and 25 pounds frequently, as well as being on your feet a lot. If you can't do that, meaning lifting up to 50 pounds for 2.5 hours of a workday, or 25 pounds for at least 2.5 hours of the workday, but as much as 5.5 hours of the workday, if you can't do that, then you're limited to light work and you should be found disabled at the age of 55. Now, there's also a special situation for people over the age of 55, even if you can do medium work. If you have less than a high school education, meaning that you didn't graduate high school or get a GED, and you haven't worked at all in the last 5 years, in that case, you can be approved for disability even if you can do medium work. The point is, the rules get easier once you cross that 55 line, but you still have to show exactly what your physical limitations are and why you can't go back to your past work. That's where detailed medical evidence becomes critical. If you're over 55 and thinking about applying, now is the time to take advantage of these rules before you miss your window.